welcome to the Personal Injury Law Show. This is a show that talks about everything relevant to the law of personal injuries and pertinent to you, the viewer. My name is Tony Carbone. I'm a personal injury lawyer of 30 years experience. With me tonight I've got a partner in a law firm in South Australia, Chris Katsoulas. Good evening, Chris.
Good evening, Tony, Vivian, viewers.
And the one and only Vivian Ryan, the marketing guru. How are you, Vivian?
Hi, Tony, Chris. Hello, viewers.
Viewers, stay tuned tonight. We're going to make a comparison of the relevant car accident laws between Victoria and South Australia and the various differences. So stay tuned for that.
What's in the news, though, Tony, before we get into it?
Well, Vivian, the first thing that's in the news, talking about car accidents, is this bike rally against helmet laws in Adelaide. Can you believe that?
I can't believe it, but maybe Chris can shed some light on that because we find it extraordinary here in Victoria. There are so many cyclists that use the roads, and for these guys to be rallying against wearing helmets, extraordinary.
Chris, it's an absolutely bizarre story. You've got people rallying against the right whether to wear a helmet or not when you're on a cycle because they say it's not that unsafe.
Yeah, this is a freestyle cyclist group. It's a group of cyclists who clearly want some liberties on the road. There are in Adelaide a number of cycling paths that are available to the public, but this particular group are suggesting that the cyclists should have an option to wear a helmet or not. But that's caused clear controversy amongst particularly people with injuries.
Well, what's interesting is that there has been undeniable evidence over years and years and years to demonstrate that the use of helmets has prevented serious injury and also, death, basically. So,
well, Vivian, I can personally relate to that. My youngest boy, when he was very, very young, was on his bike in the backyard. He didn't want to wear his helmet. I forced him to wear the helmet. He came off his bike, landed on the ground, cracked the helmet. He had a concussion for about a week. I'm just wondering, if it wasn't for the helmet, what would have happened, Viv?
Absolutely, and I think you guys in PI would be able to definitely comment on this, as having seen, I'm sure, numerous cyclists and motorcyclists who have been injured and saved from actual death by the use of wearing helmets.
There's no doubt. There's evidence that shows that without the helmet, a fatality could have occurred. And in this particular article, there have been some comments made by people who were in fact injured, and they clearly indicate that but for the helmet, they may have not survived. And
one person in the article had very, very nasty injuries, and apparently they say, but for the helmet, probably would have been dead.
Well, we'd love to hear from our viewers though, so please, drop us a line on Facebook or Twitter and tell us your story.
Let's keep moving. Viv, tell us about the Grand in the jet suit compo claim against Malaysian Airlines. Geez, they've been in the wars, haven't they?
Well, they certainly have. And continuing, this poor grandmother actually sustained a leg break on her way to a flight in Tullamarine Airport in Melbourne recently. She boarded the flight and was assured that she was going to have a wheelchair on departure in Sri Lanka. When she got there was actually no wheelchair for her to disembark with. She tried to get up and put some weight on her leg that she'd been injured on. Well, she had sustained an injury on the travelator in Melbourne Airport, and that further exacerbated the injury. And now she's claiming that I think she wants $250,000 in compensation. I find that really extraordinary that she's actually taking action against Malaysian Airlines, given that the injury was sustained on a travelator in Melbourne Airport.
Yeah, but Viv, she says that her leg was further aggravated by the lack of a wheelchair, Chris.
Yeah, I think the situation was on the travelator. She had hurt her leg and then requested some assistance to aid her travels between airport to airport and the aeroplane. And it was actually in the aeroplane on her way out in Colombo that she wasn't provided any assistance to get from her chair or from a seat to the wheelchair which was waiting for her outside.
And mind you, they said the wheelchair was going to be available, and when she got there, it wasn't there.
That's correct.
It's going to be a medical question, really, about what is the additional damage she sustained, because I think she's got a good case, Viv.
Could she arguably take action against two parties in this instance?
I think it's best against the airlines, because if you can show that they'll remiss not providing a wheelchair, Chris,
I think
then,
it actually...
you're looking pretty good.
Yeah, I think because it actually happened, the break of the leg actually happened on the aeroplane itself, and the allegation was that she had requested assistance and none was forthcoming. So I think the the airline company is the relevant party here.
And viewers, under the international treaty, that governs all the airlines. The beauty of it is there's no thresholds, and if you can prove that they were negligent, you're going to get money. Women win compensation after party bonfire explodes.
It was a party that was hosted by a young 20-year-old lad who invited 50 guests over his house. Before the guests had arrived, he had set up a bonfire, which involved large pieces of timber and some barrels, and but there were also some fuel accelerants that were within the vicinity. And during the party, one of the guests threw what appeared to be some sort of a paint thinner into the bonfire, which caused a huge explosion.
I mean, I just find this story outrageous. They're 20, they're not 5. They understand that by fueling a bonfire with thinners and fuels and then lighting a match is going to cause some serious damage. So the injured people are actually, he was ordered to pay $360,000 in damages. I don't think that that's even adequate, to be perfectly honest.
Oh, there was a few people that claimed, Viv.
Yeah.
I mean, one got $149,000 for...
But that's just nominal. I mean, you consider some of these people were in hospital for quite some time. They sustained some very severe injuries. I think is it not a criminal matter as well?
I think it is.
You would have thought so. You would have thought so.
Well, put it this way, if this happened in Adelaide, there'd be no thresholds, would there, Chris?
No.
You could claim everything, past, economic loss, future,
That's
medical
right.
expenses.
Yep. I mean, the fact that this guy held the party at his place, his relevant insurance would have covered, I would have imagined, the compensation that was paid out in those circumstances, but there are no thresholds in South Australia, so any injury sustained on the property of another potentially warrant a claim under the public liability laws. And I think these women who were severely burnt justifiably claimed.
Yep.
So I think that the message as well to viewers is if you're going to throw a bonfire, if you're going to be completely stupid, make sure you've got public liability insurance.
And also, even for example, if you had a party with underage kids and you're serving alcohol, you are absolutely stuffed, aren't you?
Oh, you just have to be careful at home and out and about.
The show's moving very fast. I want to do one story very, very quickly. The woman that wins the right to claim asbestos compensation after 19 years. Viv, just in short, what happened
Well,
here?
this is a landmark matter. It's still before the courts on appeal. The partner of the deceased party who died from asbestos has been able to bring a case about after 19 years. So that's really it's a landmark matter. There's normally a 3-year threshold, a 3-year time limitation.
Which has been overturned in Queensland. So, Chris, what comes out of this?
Well, essentially, it gives her rights to claim as a dependent. I mean, it was a husband, basically, and they had very young children, and under a dependency claim, then compensation then flows for the life of the woman, the wife, and also for the children until adult age.
And
the moral to the story also is to get legal advice, isn't it, Viv?
Always get legal advice, and there's always a way around, or there's generally a way around once you've had...
proper specialist advice. We've got to go to a sponsors break. Vivian, thanks for coming on board.
Thank you so much.
Viewers, stay tuned. After a break, we're going to compare the differences between South Australian and Victorian car accident laws. Viewers, welcome back to the show. We're going to be doing a comparison between Victorian and South Australian car accident laws. Before that, welcome aboard John Karantzis, accredited specialist in compensation. How are you, John?
Hi, Tony. Hi, viewers.
Well, John, I'll come straight across to you. In Victoria, for a motor vehicle claimant, what do they do? What's the steps?
Tony, anyone injured in a transport accident has to make a claim. You need to notify the police and also notify the Transport Accident Commission. You telephone the Transport Accident Commission, you make a claim over the phone, the paperwork will be sent out to the claimant, Tony.
And just there, when a paperwork comes, you must consult a lawyer to make sure you've done it properly.
You need to see a lawyer to make sure you filled out the paperwork properly, and in particular, especially viewers, make sure you've written out all the body parts that have been injured.
Don't forget a body part and complaints to the doctors, correct?
Exactly, because it can prove problematic, 2-3 years down the track when...
Causation.
When you want to get treatment on your right arm, for example, but guess what? You didn't write it down in the in the claim form.
Or complain to a doctor.
And you need to complain to a doctor. Straight away, you need to attend your treater and complain.
Chris, you've heard what John had to say. What's the position in South Australia?
Well, firstly, just in response to those comments, often the injury, there is one severe injury that's sustained and some other not so serious injuries, and it's often the case that the more serious injury is focused, and that's often the reason why the other injuries aren't reported.
Yeah, well, that's well put, Chris.
Yeah, but I urge the viewers to, as John said, to make sure the full injuries, all complete injuries are incorporated. But in South Australia, the process is not very different. If you have an accident, you need to report it to the police. You need to then notify Allianz, which is the compulsory third-party insurer. There is a claim form process that needs to be completed. It's a fairly exhaustive and comprehensive document, and viewers, without the aid of a solicitor, it becomes very difficult, firstly, not only to complete, but to ensure that it's completed correctly.
How long have you got to do that, Chris?
6 months.
Okay. John, how long have we got to lodge a claim in Victoria?
Ideally, as soon as possible, within 28 days.
But if it's outside 12 months, you've got problems, because then you need to get the TAC to exercise the discretion.
Exactly.
Which is problematic.
Which is problematic and could be fatal to the claim, Tony.
Just curiously, guys, when do you want to see the clients?
As soon as possible.
Okay.
Even in the hospital, Tony.
I've had this question asked of me, Chris. Client 3 years later goes, "Oh, look, I wasn't sure when to come and see you." I said, "Look, I'd prefer to see you 3 years ago because you've done things not how you should have. You haven't documented this. You haven't documented that. You haven't covered this base." It's important that things are done in a systematic fashion, correct?
The lawyer can put things on the right track.
In perspective.
And you and I, Tony, we've seen plenty of people, injured people in the hospital, haven't we, Tony?
Oh, without doubt.
And from day one, the client is at ease. And that's what we want.
Well, they've got to try and recoup and rehabilitate themselves.
Yes.
And they don't need the extra legal burden to deal with all these issues.
Oh, yes.
Don't you think?
Well, I think it's just a matter of just setting up the case correctly in the first place, and that also ensures that the correct and adequate treatment is also supplied and provided, so that there aren't any complications about that need later. Because if you don't get the necessary treatment early on, then that could be damaging to the claim as well. It could be argued that you're not putting yourself in a position to improve your condition, so you need to try and avoid that.
And it's about doing things systematically, isn't that correct?
Exactly.
Yep. All right, John, in Victoria, there's the no-fault benefits. Generally, what do they entail?
Tony, medical expenses, loss of wages, they're the key benefits.
Okay.
Anyone injured in the transport accident, again, if you're unable to work, well, you'll receive weekly payments for a certain period of time.
Exactly. Which is usually 3 years unless you've got 50% whole body impairment, which is pretty severe.
Very, very severe.
Chris, what are the benefits in South Australia?
In South Australia, assuming that liability or the cause of the accident, the responsible party, is not directed to the injured person, or at least predominantly not directed to them, then by way of a policy, the third-party insurer Allianz would generally agree to pay or fund the initial treatment needs. But then that's obviously with the provision of some medical evidence to ensure that there is a need for ongoing treatment.
And does that incorporate loss of income as well, Chris?
Well, it does. There's a past economic loss entitlement, so that gets paid as part of a claim, but generally gets paid when the matter resolves by way of negotiation.
Okay.
But in circumstances where there's hardship grounds, the insurer is prepared to consider offering an interim payment.
So fault-based system, John.
Fault is an issue here.
That's correct.
So if you're at fault, you're not going to get medical expenses, is that correct?
That's correct. If you're at fault, unless you're under 16, so children under 16 are entitled. It's become a no-fault scheme in Adelaide for children, but also for catastrophically injured people.
So really, Tony, in South Australia, there's every reason for the injured party to see a lawyer straight away.
In fact, absolutely nuts if you don't see a lawyer.
Exactly.
I mean, often the liability question is resolved with the involvement of a solicitor. I mean,
Yes.
because those issues can be very complex.
And Chris, by fault, we're not talking about someone being totally in the right.
That's correct.
It's a situation where there's could be two parties involved and it could be 50-50, is that correct?
That's right. Well, I've got a case at the moment, a lady who suffered very, very serious injuries, and she essentially was predominantly at fault. But on my assessment, I would have thought that even if she was found to have been 70% at fault, she still is entitled to recover 30% of her damages. And 30% of a large sum of money is a large amount of compensation.
Oh, it puts you in a better position than nothing.
Yep.
Isn't that correct?
Exactly. And we've got the impairment benefit, don't we, Tony? So
Exactly.
Victoria has, again, a no-fault-based lump sum scheme of an impairment benefit.
Although the meat in the claim is common law, isn't it, John?
Exactly.
What's the process in getting a common law claim off the ground in Victoria?
The case is prepared, and in essence, the injured party needs a serious injury, Tony.
Okay, so you lodge an application by affidavit, more or less.
Exactly.
Medical reports.
Medical reports, clinical
Tax
records,
returns.
tax returns.
And then you need to show 30% or...
Under the narrative test that you have suffered a serious injury to one body part as a result of that transport accident.
Chris, you've heard what John had to say about the Victorian system. How would you lodge a damages claim in South Australia? What's the process?
Well, once the condition reaches what's called maximum medical improvement, which is essentially the condition stabilises.
Yeah. Predominantly stable.
Predominantly.
Or substantially stable. Is that correct,
That's right.
John?
Exactly.
That's
Which
right.
means-
You will be how you are.
Yep.
Yeah.
Yep. So you've had the necessary treatment, you're not likely to get much better, you're not likely to get much worse, essentially.
Okay. Viewers, we're going on a sponsors break. After a break, Chris is going to tell you how to lodge a claim in South Australia, so stay tuned. Viewers, welcome back to the show. Before the break, Chris was explaining to us how you lodge a common law claim in South Australia.
Yep.
So you get an application, don't you, Chris?
Okay, once the condition stabilises, then, and you've gathered all the necessary medical evidence in support of the claim, and other evidence, of course, then you formulate your claim. It's essentially an offer of settlement in a letter form that is sent to the insurer, Allianz, outlining each head of damage and the justification or the basis at arriving at those figures.
All right, I'll come back to that in a sec. John, assuming you look dumbfounded, what's wrong?
Tony, that sounds so simple compared to the Victorian system.
Yeah.
The
Well, tell
Victorian
me
system,
why. I mean, the Victorian system, you have to prove you're seriously injured, aren't you?
You need
Don't
to prove that you're seriously injured, and you do that by, first, we have to prepare a detailed affidavit
Yes.
explaining the injured party's life from A to Z and how these transport accident injuries affect, almost destroy the person's life. And then secondly, we need medical records and medical reports from the treaters and medical legal experts to support the claim, plus tax returns, plus any other credit issues, documentation. Tony, it's complicated, it's detailed, it's voluminous, it's...
But John, thanks to our case of Georgopoulos, you only have to have one serious injury.
Exactly.
Correct?
Oh,
and
yes.
it opens the door for every injury.
Exactly.
All right, let's go back to Chris. Chris, you formulate this letter asking for $2 million, whatever you want to ask for.
The one-page letter.
And,
Well, it's not quite a one-page letter, but
and let's talk about the heads of damages. There's always pain and suffering, correct?
that is. Look, I mean, just to clarify, viewers, the need to formulate also requires proof that the injuries have reached the necessary thresholds, or alternatively, fall under the category or the definition of harsh or unjust.
So, the necessary thresholds are usually 8% for loss of income in the future.
Yep, it's 8 points on the threshold, on the injury scale
Yes.
value, yep.
And voluntary services, which is like someone helping you at home, for example, to do your hair, cut the grass, this and vacuuming, cleaning, 8% again.
it's 11 points for voluntary services and for
Okay.
pain and suffering.
Okay.
8
Okay.
points is for economic loss.
However, listen to this one, John. If you don't reach those necessary thresholds and you can prove that it's harsh and unjust, you can still claim it. What's harsh and unjust mean, John?
Tony, my view would be that anything adversely affecting the injured party is harsh and unjust.
So you reckon it picks up just about everyone? If you've got a
right.
reasonable injury.
Exactly.
Yeah.
Oh,
So,
yes.
Chris, John's saying if the injury's not just a
Minor.
incident,
And it's
he
affecting you on a daily basis, well, you have a claim.
I agree with that. Look, the other thing as well under the legislation is when you have multiple injuries, it becomes, under the South Australian laws, it becomes much more important because then the judge has the ability to increase the point value quite significantly in circumstances where there are multiple injuries that occur. So going back onto the point that we were talking about earlier, that makes it much more important for viewers to report all injuries to doctors and also in the claim process. Otherwise, that may become a problem when formulating and trying to resolve the matter.
But Chris, it gets even better under your system. Any loss of income and medical treatment, up to the date that you formulate your letter to settle your claim for common law, there's no threshold. You don't have to prove 8 points or 11 points.
That's correct.
Can you believe that one, John?
I'm surprised.
Pleasantly surprised?
Yes, exactly. Pleasantly surprised.
So you think it's just about everyone should put in a claim if they've got loss of income or medical
Exactly.
expenses?
Oh, they should be. Oh, yes. And that's where the lawyer comes in and advises the injured party on the entitlements, Tony.
Can I just comment on that, viewers? There is a feeling amongst the public in Adelaide that it is very difficult to claim because of the introduction of new thresholds. But look, the simple fact is that you need to consult a lawyer because as lawyers, we know the laws, we know the exception provisions, the harsh or unjust, and there are entitlements that viewers may have but are not pursuing simply because they fear that they may not have a case.
You get your serious injury in Victoria, and then you've still got to blue with these people, don't you?
Oh, yes. The Transport Accident Commission, they don't willingly give out money, Tony. You have to show fault. You have to show not only have you suffered a serious injury, but that the car accident was not your fault and can be difficult.
It can. I guess the one advantage in Victoria, John, as opposed to South Australia, and Chris will vouch for this, pain and suffering's not as good in South Australia, but it's a lot better in Victoria. But everything else in South Australia is better than Victoria, Chris.
There's no doubt. Economic loss, I mean, it's essentially, well, I won't say unlimited, but there are avenues to pursue economic loss claim if you have permanent injuries into the future, which can be quite substantial.
Viewers, Chris will be on for our next episode talking about the South Australian workers' compensation system, so stay tuned for that. John, is there anything else you'd like to add? We've come to the end of the show.
Tony, under Victoria and South Australia, anyone injured in a transport accident has the right to make a claim. You should see a lawyer, react on a no-win, no-charge basis. You have nothing to lose.
Chris, we're approaching the end of your episode. Is there anything else you'd like to add?
Look, I'd like to urge the viewers that if they've been involved in a car accident, then they should consult a lawyer.
Thanks for coming on board, John.
Thank you.
Chris, I'll see you next week. Viewers, thanks for watching. Go to our Facebook page, Twitter, social media. Stay tuned for future episodes and always remember to stay safe.